When was the last time you reviewed your firm's procedures for processing ACH, wire transfers, credit card payments, or other payments from your clients that are required to be placed into trust? The trust account rules require specific trust accounts to be used when processing client trust payments in electronic form. I'm Christopher Shattuck, the State Bar of Wisconsin's Law Practice Assistance Manager, and today I'm joined by Aviva, Meridian, Kaiser, Ethics Counsel for the State Bar of Wisconsin to discuss the newly created payment from client flow chart, reissued trust accounts options chart, and electronic banking chart, which all help determine which trust account is required to process payments and costs from clients. I recommend that every lawyer or staff member being supervised by a lawyer that are processing client payments have these charts up on their walls. Aviva, thank you for creating these charts and joining me today.
Thank you, Christopher, for this opportunity to talk about electronic banking. The purpose of our discussion today is to demonstrate how these charts are used and how they can assist lawyers in processing their payments from clients.
Thank you, Aviva. So you and I have provided many consultations to lawyers that do not understand that a separate trust account, either an e-banking or an all-in-one IOLTA, is needed to process electronic trust account payments. Let's start with the electronic banking flow chart. Could you talk about the general rule prohibiting electronic transactions to and from a standard IOLTA account and the three exceptions?
So the purpose of this chart is to introduce us to the general rule prohibiting transactions that are electronic into and out of your trust accounts, and to introduce you to the three exceptions to that general rule. So those three exceptions are remote deposits, the e-banking trust account, and the alternative to the e-banking trust account. So remote deposits are those deposits that are checks that can be electronically imaged and deposited into your account. Remote deposits are permitted in all three types of the trust accounts: into your traditional IOLTA account, into your e-banking trust account, and into your alternative to the e-banking trust account. The second exception is the e-banking trust account exception. Electronic transactions are permitted into and out of the e-banking trust account. However, you want to make sure that when those deposits are available, those deposits must be transferred immediately or within 3 days into your traditional IOLTA account. Consequently, the funds that are at risk for online theft are only in that account for that limited period of time, and it's only that amount. It's not your entire trust account. The third exception is that alternative to the e-banking trust account. That again allows you to take electronic transactions into and out of that account. However, the lawyer must have that crime bond policy to protect those funds from online theft. Remember, it's your entire trust account that's at risk there.
In your discussion of the rules and exceptions regarding electronic transactions, you mentioned three different types of trust accounts. The recently reissued trust account options chart provides an overview of these different options, including security requirements, permitted and prohibited transactions. Could you provide a brief overview of how this chart can help a practitioner determine which account to open or whether a separate trust account is needed?
Yes, Christopher, there are three different types of trust accounts. So if a lawyer is not taking electronic payments into their trust account, other than remote deposits, then that lawyer needs only that traditional IOLTA account plus their required business or operating account. If, however, that lawyer is taking electronic transactions or payments into and making them out of their trust account, they have two options. They can choose the e-banking trust account, or they can choose the all-in-one or the alternative to the e-banking trust account. So what this chart does basically is help the lawyer compare what the security requirements are for each of those accounts, what the permitted transactions are for each of those accounts, and what transactions are prohibited from each of those accounts.
Thank you for the overview of the trust account options. As we transition to the payment from client flow chart, I wanted to focus your attention on the business account only option, which you have discussed previously in conjunction with other trust accounts. Could you please explain when a business account can be used to process electronic payments from the client and how using the alternative protection for advanced fee language in a fee agreement may also modify how certain payments are processed?
So the payment from client chart is a way for us to show you how we actually process those payments. So you'll see right away that there's 3 different types of payments that we have listed here: fees only, fees and advanced, costs combined, and then costs only. So if you look at this chart, you will see business accounts in 3 different places. Now, so let's talk about what kind of payments can be deposited in that business account. So we'll start with payments for earned fees. So for a payment for earned fees must be deposited in a business account. It belongs to the lawyer. The lawyer earned that payment. Payment for advanced fees that are subject to that alternative protection provision that you find in the fee rule at 1.5G, those may be deposited as well in your business account. Keep in mind that those alternative protection provisions must be communicated in writing to the client, and the easiest way to do that is in your fee agreement. So then the next part is, if you see incurred costs, those also must be deposited in your business account, because again, those are costs that the lawyer has paid for, and that the client is now reimbursing the lawyer for those costs.
Now that we have run through the business account option, could you walk us through and explain the rest of the flow chart?
Certainly, Chris. As we saw with the business account, payments can be made into the account either by check or by electronic transaction. The trust account rule does not govern the business account. However, payments that must be made into the trust account are governed by that rule, and depending on the form of the payment, whether it's check or electronic transaction, that will determine which trust account it must be deposited into. So let's take a look at what types of payments must be deposited into a trust account. We know that advanced fees that are not subject to the alternative protection provisions of 1.5G must be deposited into a trust account. We also know that advanced costs must always be deposited into a trust account pursuant to that 1.5F. And we know that any payment that includes a combination of advanced costs and fees of whatever type must be deposited into a trust account, because advanced costs must always be deposited into a trust account. So let's look at some examples to show us how that works. So for example, a combination payment that includes advanced costs and advanced fees that are subject to that alternative protection provisions must still be deposited into a trust account. Why? Because advanced costs must always be deposited into a trust account. Then, after that money is deposited into a trust account, the amount for the advanced fees may be transferred to the business or operating account. So another example is if we have a combined payment of both advanced costs and earned fees. Those must still be deposited into the trust account. Why? Because advanced costs must always be deposited into a trust account. Then the earned fees may be transferred appropriately into that business or operating account. So another example, what if we have a combination payment of earned fees and advanced fees that are not subject to that alternative protection of 1.5G? Again, that must be deposited into a trust account. Why? Because advanced fees that are not subject to those alternative protection provisions in 1.5G must be deposited into a trust account. Again, when those earned fees may be transferred or must be transferred because they're earned, must be transferred to the business or operating account.
Thank you, Aviva. And what I really like about this chart is the way that you break this down. So when you talk about those fees that must be deposited into a trust account, then depending on the form of the payment, which you referenced earlier when you were responding to the business account difference, the form of the payment will determine which account that goes into. So as you said, if it is an advanced cost and an earned fee, that must be deposited into a trust account. And then if the payment is in form of an electronic transaction that is not subject to an exception, then the lawyers or law firm must use either the e-banking trust account or the alternative to the e-banking or the all-in-one trust account, and then transfer appropriately as those fees are earned. So thank you again for providing an overview of that chart.
Thank you for the opportunity, Christopher.
Any other recommendations or advice you would like to provide?
Yes. First of all, please feel free to contact Practice 411 and our wonderful manager, Christopher Shattuck, for information on how to set up that trust account. He's extremely helpful. And contact the ethics hotline for advice on trust account rules. And again, all of us are so happy to help.